Hello, I am Brent Salmons, partner at Husch Blackwell. Welcome to today's webinar. Before we begin, I would like to cover a few housekeeping items. At the top of your audience console, there are multiple applications for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all the questions during the webcast, but if a fuller answer is needed or if we run out of time, we can answer those later via email. A PDF of the presentation is available in the Program Materials folder. Auto-generated captions are available for today's program. Turn on closed captions, click the CC button at the bottom right corner of the player box. This program has been approved for legal education hours in some states. I think the list was displayed on the screen earlier. For live attendees, report your hours by clicking on the continuing education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And that's the housekeeping item for today. So let's get started with our program. Again, I'm Brent Salmons, partner at Husch Blackwell, and joining me today is Michael Brandis, also a partner at Husch Blackwell. All right, our lead off is kind of, I guess, a background of where we are in the cannabis industry in general. The tail end of the Biden administration, there was an effort to reschedule cannabis from Schedule 1, which is essentially prohibited, and for the cannabis industry leads to having to keep everything isolated to certain states, and most notably for the purposes of today's program, 280E treatment, which is shorthand. 280E is a draconian tax provision which prohibits you from deducting most of the expenses in conducting your business. We have had discussions with various people in the industry who are to various ways connected to further or lesser extents into the Trump administration. And they tell us that the potential for rescheduling is continued to be discussed there. Although it sounds like there's a division of opinions as to where to reschedule it, that there are some people who are in favor of leaving it alone, some people who think that it should be rescheduled to Schedule 3, and some people apparently are thinking that it should be rescheduled to Schedule 2. Schedule 2 drugs are kind of more like drugs that have some medical use but are fairly restricted. Examples: Adderall, fentanyl, morphine. The problem with being rescheduled to Schedule 2 would be that 280E would still apply to the cannabis industry as we know it today. Schedule 3 drugs are things that are, less restricted: steroids, hormone replacements like estrogen and testosterone. And if it were rescheduled to Schedule 3, then 280E would no longer apply, which would obviously be tremendously beneficial in terms of federal tax treatment. So still don't know how that's going to shake out. I don't know that we've gotten any kind of clear guidance beyond just rumor mill at this point.
Is it fair to call 3 the fun ones and 2 the less fun ones?
Yeah, I think that's fair. That's absolutely
fair enough.
Go ahead.
I just wanted to bring it back real quickly. First of all, I'm Brent, as you noted, far inferior partner. I practice in cannabis, but also distress, insolvency, turnarounds, restructuring, things along those lines. And we're both business attorneys at the end of the day. And so what we're talking about is money and how rescheduling would have an impact on this industry from a money perspective. What is the implications of rescheduling? What does that mean? And Brent will hit 280E in a second, but like what happens here if these things happen? And then in terms of the Trump administration and the Biden administration and so on and so forth, I think it's very important to point out that there are just considerable, this is a multi-billion-dollar industry with thousands of employees. And as we've seen with crypto and other areas, when you have that much money in an industry, it makes sense for them to have lobbyists, and those lobbyists are going to, their job is to affect legislation. And so they're trying to do their job right now, which is to say, hey, the industry, and we'll get into many of the instances of why there's financial distress in a moment, but um, you need to make it easier for businesses to be in this business. That right now it is very, very difficult, and that the administration federally can take a position that would make it a lot easier, a lot more financially lucrative to be in the business for equity and really a better investment for everyone all around. So what Brent's talking about is really important in terms of the viability of this industry on a go-forward basis. Do you want to hit 280E and explain what that is?
Sure. 280E is a section of the Internal Revenue Code that was put in place, years back as part of the drug war, essentially, in which the rules were set up that if you were operating a illegal drug business, you are selling Schedule 1 drugs or Schedule 2 drugs, and you're selling Schedule 2 drugs without, prescriptions and following the rules of the FDA and that type of thing, that you are allowed to calculate your taxes only by deducting the cost of goods sold, and then every other expense, like basically every SG&A expense that you could think of, which would be, most of the expenses of a lot of businesses, are disallowed in calculating your income tax, which the net result of which is the income tax burden at a federal level is dramatically higher for cannabis business than any other business that is legal at a state level. Some states also apply this, although a lot of them have tried to, at least for cannabis businesses, have tried to kind of set their tax system up so it's disengaged from the federal tax system on this particular issue. But a lot of states' tax systems were set up to basically just mirror the federal system in a lot of ways. And it's resulted in, essentially cannabis businesses being money losers if they were to have to pay the federal income tax. I know a lot of them have filed tax returns and basically just said, we owe you a bunch of money, and then not paid it. And it's certainly one of the things that's leading to general financial distress in the cannabis industry. It's not the only issue, but it is a significant issue. And if it were to be solved, it would dramatically improve financial returns for everyone in the industry.
That's right. And getting to what's happening around the country, it brings me back. I was born in 1982, and that's, I know Reagan was in office when a lot of alcohol legislation was enacted through, I think, basically incentivizing different states to raise the statutory age limit to 21, and I think Wisconsin still had like 12-year-olds drinking beer, which I love Wisconsin. And so they were going to withhold highway money, and I could be completely wrong about this, but this is my understanding. They were going to withhold highway money if Wisconsin didn't raise the limit to 21. And so, like alcohol, but worse, the statutory framework for cannabis is very patchwork. Illinois is different from Wisconsin, which is different from Indiana. And not just that, but certain states will take a law and then the regulators are interpreting it in different ways. And so there is sort of a fluidity in terms of trying to interpret in the legal side exactly what's going to be appropriate and allowed for today, and based on what happened yesterday. And there's just not a long roadmap for yesterday. And then from state to state, it's unclear exactly, how everything is coming together. You have states like Texas where are taking much more stringent action against the industry. You have other states where they're dipping their toes into cannabis and trying to figure out exactly where they want to go with it. And it's, I guess the word that would be appropriate going back to high school is experimentation on a statutory basis. And that, it's like tariffs. It's like, how can a business properly plan for the future without knowing exactly what the rules of the road are? And the rules keep changing over and over again. I was looking at the CLE list. It's Illinois, Iowa, Kansas, Minnesota, Missouri, Nebraska, Tennessee, Texas, and pending in Colorado and Wisconsin. And those are the states that CLE for this presentation are pending. And I mean, each state in the CLE is just incredibly treating cannabis incredibly different than each other state. And so
That's for sure.
it's interesting to see. Should we hit a few of the individual states as we're talking about this?
Yeah, I mean, I think everybody that's in the industry understands that there's a general financial distress in certain states, not every state. I think that the general rule is the longer that you have had cannabis legal for adult consumption, the harder the harder that state is to perform these days. So Colorado and California were the first movers. I think Washington probably similar, and they're the ones that are having the most distress. I think that I generally think that what has happened is that as each state kind of legalizes it, there's a little bit of a gold rush mentality, right? Everybody's like, oh, there's a big business here. It's virgin territory. We're going to go in and we're going to invest a lot of money. There's a lot of money that sloshes around the system for several years. And then I also think Colorado and California essentially built with the idea that it would be legalized at a federal basis in a not too distant future. And there was a lot of overbuilding as a result of that. So anyway, I think Missouri being one of the most recent ones to legalize it for adult use is doing quite well. It also has helped, particularly on the western side of the state, due to the fact that Nebraska and Kansas are still, I think, fully illegal for cannabis. One of the few states, those are both two of the few states that are holdouts in terms of you can't get it with a prescription. There's no medical, there's no permitted use at all. And so you've got traffic coming over the state line to buy it in western Missouri. You want to talk to the Illinois receivership?
Yeah, we're going to get to the various, essentially vehicles of restructuring and insolvency and so on and so forth. And Illinois historically didn't have a statutory receivership law. And so what I mean by that, and I'm not going to assume everyone in our audience understands this, there's really two ways that laws are made. The first way is through statutes, meaning that the Congress for that state passes a law that says you can cross the street. And so there is a law that says you can cross the street. Second is what's called common law, and that is that the state doesn't have a law concerning crossing the street, but the judiciary has come out with opinions. So a judge has said, of course you can cross the street. It's necessary to cross the street if you're going to have shoes or whatever it may be. So Illinois has had common law receivership for companies, but no statutory, and that has made and I think it's an important point. I'm going to back up very quickly because for state of affairs, because cannabis is federally illegal, a cannabis company cannot file bankruptcy. And that is because bankruptcy is a federal relief. It is a federal vehicle. All right. The order for relief is a federal means of reorganizing or liquidating assets. So if a cannabis company is in trouble, what can it do? We're going to get through a few of the options during this call today, but receivership is a commonly used mechanism to essentially not reorganize, but sell the cannabis enterprise or its assets through an organized method. So we'll hit that today. But Illinois passed a new receivership law. There are now going to be corporate receiverships in Illinois. I imagine there's going to be cannabis receiverships in Illinois. And that goes effective, I believe, January 1st of 2026. So it's another vehicle that will be available to Illinois entities. And we're starting to see a little bit of turbulence here in Illinois. So I expect it'll be used. Should we move on?
Yep, I'll do it. All right, so our next topic of discussion is really like what are the common things that kind of lead a company to have to go into a receivership or an ABC? That's one of the, we'll touch on that a little bit later, an assignment for the benefit of creditors. For some of them, it's the cost of remaining public. Most of them, most of the public cannabis companies are public in Canada. There are a few that are public in the United States that essentially morphed into cannabis companies after going public. But the cost of being public is substantial, right? Yeah, there's a fair amount of legal and accounting fees that are associated with that on an ongoing basis. And when your business is struggling, the benefit of being a public company really turns into a burden. And I think you're seeing that in the case of a lot of the kind of like smaller to mid-tier cannabis companies that thought going public would be a good way to access cheaper capital because they were trying to sidestep the cannabis premium on raising equity and debt. And I think that's as things have turned against them, that's really turned into an anvil. Cost of capital, as I just alluded to, in the cannabis industry is high. It's higher than most any other business. Basically, most of the costs of doing business in a cannabis company are higher than a lot of your other businesses. Rent is higher. Landlords demand a premium because they're dealing with a federally illegal business. It's harder to find banking, and when you do, it's going to be more expensive. Borrowing from lenders is primarily private lending or funds. It's not going to be from your bank down the street. Or maybe some credit unions and smaller banks, but primarily those are focused on real estate collateralized loans. And then equity demands a higher return as well. So those are the things, those are like higher costs. And the next one as well, the cost of entry, right? There's a lot of security requirements. There are a lot of hoops you have to jump through to keep your license with the state. They want to make sure that the product isn't being stolen. The stores have to be built out in a certain way. Most of your cultivation is indoors with grow lights, so all the associated utility costs, et cetera. Building out a facility to grow or sell cannabis is an expensive enterprise. And so these costs stack on top of each other. And then if you have a management team that is not sophisticated enough to handle that, you have a problem. Or if you have states that are not limited in licenses, so you have over competition. In my mind, the classic example is Oklahoma. Oklahoma has no limitation on licenses, and so you can get a license for $2,500 or something like that in Oklahoma. So there are cannabis licenses all over the state, and it's exceedingly dog eat dog in terms of competition there. And then some of your problems in terms of like not letting lenders or investors know that you're running into trouble when they could potentially help you, because I think a lot of times people view investors or lenders as possibly their enemy when they really are not. They want to figure out a way to get a return on their investment. It can cause you to go down a spiral which you can't recover from. And then we already talked about 280E and CDTFA and similar taxes. Those are essentially the state and local excise and sales taxes, which if you're in the industry, are very significant. And then you couple all of these things together with, I think a lot of states have essentially stopped enforcing illegal sales of cannabis. You're competing with a black market that's undercutting you. It's all recipe for a difficult market.
Yeah, and getting to sort of the macro issue, this is a business with paper thin margins. And there are businesses with paper thin margins. They exist and they are successful. But what we've seen, at least in the opening stages of really the cannabis industry, it's still somewhat in its infancy. Perhaps it's a toddler at this point, but a lot of the individuals who ended up getting licensed were people already perhaps in the industry illegally, people who may understand the product, may understand grow. But what we're talking about is a business that really needs to run very lean. And so what the skill set is needed is really someone who understands it's a paper pusher. It's someone who understands how to run a very lean business and what that looks like and what cost of resources are, what, who your customer base, pricing, things like that. And even vertical integration, which means you have cultivation, you've got branding, you've got retail, which is pretty common in this industry to streamline cost. even in those situations, it's very hard to make a buck. Um, the cost of capital, this is a risky investment for all of those reasons. And so
Hmm.
we represent a number of lenders in the cannabis industry, and the rates are high, but I think they're appropriately high. It's not exactly clear what the collateral is going to be worth tomorrow, and so they need to price accordingly, knowing that it's a risky venture. Um, in the event that there's ultimately more of a federal appetite for it, it's going to be, it's in my mind, it's a question at what point institutional lenders become more comfortable with lending into this industry, because that's the point where the cost of capital goes way down and this becomes much more of a right-sized industry. I don't think that's happening anytime soon. I think the 280E will likely be addressed, which will alleviate a lot of stress. Um, but I can't see the federal government just ultimately giving enough of a green light to let Jamie Dimon start pushing tons of cash into this industry. And then
Yeah.
CDTFA, I'm sorry, Brent, I'm
No,
talking.
no. Yeah, I was just going to say you're right in the sense that if you're a Wells Fargo or J.P. Morgan or Chase, whoever, and you have hundreds of billions of dollars in value, touching the cannabis space does not make sense for you, right? Because it's not a big enough industry for them to move the needle dramatically. Like maybe it would increase their profits for the quarter or for the year by 0.01% or 0.1%. To risk all of your other stuff if the federal government decides to turn on you and say, hey, this is all illegal and you knew it's not worth it at all. That's why you see the small players, the local credit unions, the small banks. They're the ones who are tiptoeing into the space because for them, it moves the needle. It's worth trying out. There's a lot less at risk for them.
I wanted to briefly explain what the CDTFA is and why this is such a big issue. The CDTFA is essentially it's the sales tax in California, and each state has their own sales tax. That's why they're legalizing cannabis. It's because their schools are underfunded and the roads have too many. I'm looking at Chicago. The roads have too many potholes and the budget has too many potholes, and so they need cash. And so they're saying, okay, well, we're going to allow for this industry to become legal, and we're going to charge a significant amount in taxes for it. But the thing is that the penalty for not paying the taxes historically has been lower than the cost of capital. So what's been happening is that these operating teams have somewhat prudently said, well, we're just going to default on the sales tax as opposed to the loan that we took out with the lender, because the lender is going to take our hides, whereas the sales tax is going to we'll get on a payment plan of some sort. Well, what's happened is that the regulatory bodies, the taxing authorities, have said no, not going to work. What we're going to do instead is we're going to assign personal liability for unpaid sales tax. So now you, person responsible for paying this tax, CFO, president, CEO, whatever you are, if you are responsible for paying the tax, then in the event there's a shortfall, you're going to pay it or we're going to sue you. And so when Brent and I airdrop into these situations where it's pretty dicey, it is if it's not the first question, it's in the first five. What do you owe in sales tax? And while California may be more aggressive about it than some of its neighboring states, I imagine that California is like that because they've encountered it more, and that other states will, if they're not doing it already, follow suit.
Yeah, that's right. Sales and use tax and excise tax, they can attack you personally. And I think in California, their kind of rule was essentially if you were the one who decided to pay another bill rather than pay the taxes, you are personally on the hook. So if you're the tax manager or you're the CEO and you had a hand in that decision, they're going to try to come at you. And while everything's going well, if it might make sense from a business point of view to incur the 10% penalty and then pay the interest at like relatively low rates because it's cheaper than borrowing money from a cannabis lender. If things don't turn around at the end, you're potentially putting your house at risk. And so, yeah, that's definitely at the top of the list when the business starts hitting trouble. So, all right, we want to go to the next one.
Let's do it.
All right. We have now entered the realm of receivership.
Welcome.
I know, scary. I mean, it's obviously bad for the equity, right? Because this essentially means that the equity has been zeroed out. Now, once you hit the receivership or the ABC, I think everybody has seen the handwriting on the wall, but that's kind of like the official, you're basically done. That's not always the case sometimes if you have a big operation. That may not necessarily be the case for the management team, because they may get some sort of incentives on the business on the back end. But if you were just a money investor, you've basically been zeroed out here. So that's not great. Anyway, so what are the kind of big problems that we've seen in receiverships? Michael, you want to jump on that for a minute?
And let me sort of I'm going to give a real backdrop very quickly on so companies generally stay in control of their own business in America, the operators. So what's happening is operators are saying, the CEO is saying, well, what do I have to do to A, keep my business, and B, avoid any personal liability? Things are rough. I'm not paying my debts as they come due. I'm barely keeping the lights on. I can't pay for new inventory. I've got these, lawsuits popping up where I'm not paying, vendors for amounts due. What am I doing? And eventually the lender has its own problems, which is like a pharmacy, like any regulated industry. They can't, if, outside of real estate, they can't really just go and foreclose on their collateral. So you've got a weird problem where it's like a standoff between your lender, your operator, your trade creditors, and everyone's trying to figure out, okay, the company is in trouble, but what are the next steps? And ultimately, it'll be the lender most likely who says eventually, this is not workable, it's no longer tenable, and so we need to run this through a receivership. Sometimes equity, the ownership will get on board. We've seen in certain instances, and war stories are supposed to be at the end if we have time, but where there's a creative proposal from an owner operator to its lender, where there's essentially a reorganization through a receivership. And that is where, and I think I'm getting a little hyper technical right now, but basically company's in trouble, equity is worthless because there's so much debt. And so the question is, okay, how can equity stay in control? How can the owner stay in control? And one way is to run it through a receivership where it's essentially an asset sale. And the main thing is what's the value of a business? Sometimes if you think about Nike, it's the brand name, it's the manufacturing components. For a cannabis business, it's often, the branding, although less and less. Depends on the brand, I guess. It's the client base. It's really the licenses. The licenses have, in most instances, significant value. And so receiverships are there really for the transition of a license from one entity to another, while the lenders keep a tight control over everything so that the business doesn't continue to go into waste. And then insurance, malpractice, handling of multi-state operations. I mean, it's interesting also, we're seeing receiverships in different states where there are assets in other states. And so say I'm involved in a receivership right now in California, and there's some dispensaries in Illinois, and the question is, okay, how do we deal with this? And we're all trying to be creative about it because it's an interesting issue. Brent, did you have anything to add?
Yeah, I mean, I guess I would just say that there's a couple things as you're going into a receivership, whether you are representing the receiver or the company or their creditors, you want to, I think, take a hard look at the business and decide whether you want to try to continue the business or not, right? I think that most people have a view that an operating business is worth more than a non-operating business, but that may not always be the case. It may not be worth it, right? Because the time that it takes to transfer a license in the relevant state is probably going to be 6 to 12 months, right? It's a long process. The states keep a very tight rein on who can have cannabis licenses. And so if you're thinking, I've got to run this business at a loss for 12 months. Because if the business is losing money, even if you aren't paying on the debt, it may not be worth it, right? So I think that's kind of like first thing that everybody should really take a look at, and because there's really only a few buckets of value in a cannabis business. There's like the license itself, the cannabis product that you are growing or selling, which you can't own unless you have the license, unless you have a receiver that's approved by the state, and your location sometimes, because most of the time the license is tied to a location, and then finally the cash that's generated. And if as a creditor, if you can get the control agreement that you can grab onto that potentially. But those are really the 4 buckets, and 3 of them are keyed off the license itself, the inventory, and then the lease location or the owned location, right? They're all tied together. But I think you just need to understand whether it's going to be worth it to run it for a long period of time, because it may not be. So, all right. So we've now hit a receivership. I'm just gonna point out that in different states, who can be a receiver for a cannabis company is more or less restricted. Some of them require you to have a card with their cannabis regulatory agency before you can be a receiver for a cannabis company. So that may add a little time on the front end to get, if you don't already have it, to get that before you can go into the receivership. Or if you're looking to put a company in a receivership, you got to find somebody who's got that authority. Otherwise, you're not going to be able to do the way that you think you are. So anyway, how it works.
I don't know. Do you? I'm just kidding. No, I'm
Why
messing
are we
around.
here? Oh no.
No. We probably should have backed up with how it works before we got into the receiverships. But basically, what generally happens is that a party is chosen usually by the lender, and the lender is saying, okay, you've defaulted on your loan. There's some real issues here. We no longer have faith that the operating team can manage the business, and we ultimately think that everything should be sold. So we think that the way to do it is a court process. And again, bankruptcy is not viable. It's not allowed. So what we're going to do is we're going to choose Jane or John Doe, this person who is authorized to take possession of the business. And we're going to file some action, usually a complaint, depending on where the state is, that installs this person and gives them authority to oversee operations and make certain decisions such as sales. And because receiverships have a lot of, generally in most states have a lot of, courts have a lot of discretion as to the purview, as to what the receiver can do. A lot matters in terms of what goes into that receivership order. What can the receiver do? Can the receiver borrow money? Can the receiver sell assets? Can the receiver collect and pay vendors? Can the receiver fire employees? These are all things that need to go into the order. You can go in broadly in terms of the scope of authority. But generally speaking, if you're the lender and you're saying, I need to put this company into a receivership, you want your receiver to have broad authority. It's going to be important that that's the case. And so the receiver is ultimately in charge, but the receiver also is beholden still to the lenders and various parties during the receivership. And so the lenders still maintain their security interests, nothing changes. And they can, and so there's a dance that goes on. It's just perhaps a little more organized than it was pre-receivership in most instances, unless there's litigation. And it's under the court's purview. So if there's a disagreement, that disagreement goes before a judge and the judge decides. I'm going to jump to the end, and then we'll jump back to the sort of the costs of it in a moment. But all courts are not created equal. And what I mean is some courts have more experience with receiverships. Some courts have more experience with cannabis receiverships. I was recently in a case in California where the decisions that were coming out incredibly slow. And the implication was the receiver did not know what authority he or she had. And so it put the company in some sort of a stasis, which is really bad for the company because the company doesn't know what it can pay or not pay, doesn't know how it's going to operate, doesn't know what it can sell, and all the while, all of its creditors and stakeholders are getting more and more agitated because they don't know what's going to happen, and they're taking their own moves. They're making their own decisions to be as protective as possible. And there was another matter I was involved in Massachusetts, and the court didn't know whether or not it could initiate what's called a stay, which is an injunction against litigation and other collection actions, and didn't know whether or not it should do so on a case-by-case basis, whether it could do so out of state. So if an issue was raised out of state, and so you have courts like that, and then, like I said, Illinois is getting its own receivership law, and so while there may be some limited experience with corporate receiverships in Illinois, they're all going to be common law. No one's going to have any experience with the statute until July 2nd or January 2nd, because it's the first day after the Receivership Act is enacted. So you're going to have courts trying to figure it out, interpreting laws, and those interpretations of the law are going to have financial implications, because the business is going to be trying to figure out, what do we do while we're moving forward? The court's going to be figuring out, and unlike most businesses, you're also going to have regulators in there. I'm talking for a while. Brent, you want to jump in?
No, I think you've covered that. I was like thinking, I'm over here thinking about, the third bullet point we have, which is who's the boss, to reference an old TV show. And from the point of view of the people who threw the company into receivership, the creditors, how, assuming that I'm correct, that the person who's the boss is the receiver, how do the people who put the company into receivership try to exercise influence over the receiver, or control or limit what the receiver can do?
And it depends where you sit in the cap stack and what you get in the order. So we had a matter where we negotiated certain rights for one of our clients that gave them some leverage in negotiations. And so, again, I really, in receiverships in particular, like to point in that initial order as an integral time when a party, whether it's a secured creditor, trade, whatever, landlord, they really need to keep their eyes open and participate in that process, because the company and its primary lenders are going to try to railroad everybody, because the goal of a receivership is to make the business more healthy and viable. How do you do that? You wipe out your trade debt. You wipe out you get rid of as much as possible, and you wipe out your subordinate secured debt to the extent that the collateral is not worth anything. And so making one company healthy may be really harming a lot of people along the way. And we've represented both sides, and it's why it can be a collaborative but also adversarial process, and everyone needs to have sophistication to really understand their rights and remedies and roles to play in this game. And then a DIP loan, I've been told that we recently represented a lender making what's called a DIP loan. A DIP loan is a debtor in possession loan. It is a loan made to an entity in an insolvency process. And so you may say, why would a lender make a loan to a company in an insolvency process? And the answer is, being broke in America is super expensive, like very expensive. And so to go through a receivership process, you're paying all of your normal costs of business, which, by the way, you can't pay for, otherwise you wouldn't be in receivership. And on top of that, you now have a professional team and court costs. So you've got this additional cost on top of all of the other costs that you couldn't afford in the first place. So you, in many instances, have to figure out, well, how am I going to pay for this? And the most natural way to do it is to go to to an existing lender. And this happens in bankruptcy in non-cannabis space. This happens elsewhere as well. But and say, well, your collateral is worth $100, and if there's a fire sale, we're going to get $20 for it, because no one, it's a fire sale. No one's going to pay a lot. But if we go through a process, we'll get $120 for it. And so if you lend us $10, then we know you're owed $90, but we're going to get you back $100, and then we're going to have another $20 to pay out to other creditors. So lend us 10 more. We know that it's a risky proposition, but the benefit to you is you're not going to lose, your collateral is not going to drop from $90 to $20. So it's real
But the
reason.
dip lender gets to jump to the top of the list to get paid, right?
Yes. Generally speaking, I mean, it's subject to negotiation and fist fights as well, but a dip lender usually primes other lenders as a
I guess
condition.
this goes back to depends on what the court order says.
We had one where we represented a lender and it was approved as a priming debt over the objection of other lenders. And the receiver made a phenomenal presentation to the court explaining why this was in the best interest of the state and all of these subordinate creditors, including the secured creditors, because absent it, we were looking at a fire sale, and that would be, really the worst case scenario for the estate.
But most of the time, you only need a dip loan if you have made a decision kind of at the beginning of the process that it does make sense to keep the business going and not just shut everything down instantaneously, right?
And that's absolutely right. And I'll note that in many instances, the loan comes from existing senior secured debt. I don't know that dip loans are. I've been told we had the first dip loan in California for a cannabis company. I don't know if that's true or not, but point being, it's not entirely common. It's not entirely clear what courts will allow in different jurisdictions. But if you're thinking about receivership, you also should be thinking about who's going to pay for it. How's it going to get funded?
Right. And from a senior secured lender point of view, it often would make sense to advance the dip loan, because if they don't, we're doing a fire sale. And they're owed $50, right? We're doing a fire sale. You're only going to get 20. But if they advance another 10 or 20, now they're owed a total of 70, and you can get 100. They're like, okay, well, now I got a full recovery. As opposed to, if I just let this all go, I'm going to take a 60% haircut.
That's right.
Yeah. Okay.
We know that, this
ahead.
is what we live to our audience. This is my day-to-day. This is Brent's day-to-day. If you have questions, we do encourage you to reach out. Happy to spend some time on the phone with you and answer any inquiries you might have.
You can, like I said at the beginning, you put a question in the Q&A box, or you can go to hushblackwell.com and email us. All of our contact information is there. Now let's switch gears to ABCs.
Yes, my favorite. So ABCs are very similar to receiverships, except for two integral issues. The first is in Illinois and California, they're out of court. So let me back up. An ABC is an assignment for the benefit of creditors. It is a vehicle to go through an insolvency proceeding, generally a liquidation, also can be used for reorganizational purposes. And they're legal in, I think, like 23 or something states, maybe 28 states, not legal in every state. In Illinois and in California, they are out of court. And so it is an out of court means of either selling or restructuring a company. And so the primary benefit in other states, what happens, how it works is the company says, I'm in trouble. I need to wind down. I need to go through a sale. I need to become a healthier company. And in lieu of a receivership where my lender is going to choose who the third party person is, and that third party receiver may sue me because of some fraudulent transfer or something I did that may not be totally above board. I'm going to choose the person. I'm going to choose the receiver, basically. And that's the S&E. And so the company assigns all of its assets, has to be all of its transferable assets to this third party, like a receiver. And the third party goes through a similar transaction as in a receivership, except again in California and Illinois, it's out of court. So we've seen instances in which cannabis companies have gone through an ABC as a going concern subject to a master services agreement. And that means that they can continue to operate the license during the ABC, during the sale process. And so it's an effective means of a company saying, we're throwing in the white flag And because we're choosing the intermediary, we're choosing the third party neutral party, we're less likely to get sued. We're more likely to have someone who's effective. From the lender side, it's okay, well, maybe we like this because if it's out of court, it might be a lot less expensive. And so that has some value.
Well, there's a couple points about ABCs that I think, I think need to be kept in mind. It's like everything else in the cannabis industry, it's heavily state specific, as Michael was alluding to, right? There's only some of the states allow you to have an ABC at all, but notably, I think there are a handful of states, Illinois and California, most notably, that allow you to do an ABC out of state. Out of court. I think one of the other key distinctions between a receivership and an ABC is that the company itself has to enter into the ABC on a voluntary basis, right? It's the equity, the board, whatever the management team is there has to decide, yes, we're going to do this. They enter into an agreement with the assignee and they say, here, assignee, I'm transferring all of my assets to you. And now you're in charge, to answer one of the questions on the slide already. Is that fair?
I'm sorry, Brent, go on.
I think those are kind of like the key distinctions, like who's triggering it. That is very state specific. And in some of the states, you're not in front of a judge and there really is kind of no like third party overseeing the entire process.
That's right. There's another nuance as well. So the third party often dictating what type of a process to go into is often a buyer. So say Cannabis Co. wants to buy an operation in Illinois, and Cannabis Co. is saying, this is great, we love it, we think this is exactly where we need to expand, so on and so forth. But we need an order that says we are buying it free and clear of all liens, claims, and encumbrances. We need to have fresh title on everything. An asset can be sold as in a normal asset purchase without unsecured debt following it, no problem. It's not necessarily going to have successor liability issues. That is where the new company is responsible for the debts of the old company. But the liens will travel with it in an ABC unless the lender releases its liens. So the lender in an ABC is a necessary party like receiverships and saying, well, hold on a second. No, you can't transfer this stuff, not without our authority. At least you can't transfer it free and clear. Whereas in a receivership, you can get that court order. The nuance is there are places like Florida, which has basically in Minnesota and Wisconsin, where an ABC is the same thing as a receivership. It's just a question about who chooses the person running the show, in which case the cost remains the same as a receivership. The functional means of running the process are the same. It's just who's choosing the person. And you can likely get a court order that provides for some of the relief you're requesting, but lenders in either ABCs or receiverships just have, particularly senior lenders, have a lot of control over the process.
So to the point of how it works, we don't have a court order, right? Like we did in a receivership. We don't have the judge saying, okay, here are the rules of the road. I'm going to set out everything out. Is the way that it works essentially a function of the agreement between the assignee and the company?
Yes.
Okay. And then again, that's the company that's going to be implementing that, presumably with the agreement or over at least some sort of involvement with the senior secured creditors.
Additionally, one thing I do with ABCs that I particularly like is, again, it's particularly for there's two types of ABCs in receiverships. There are going concerns and there are liquidations. For a going concern ABC, what I like to do is try to run, if I can, with the lender's consent, run the investment banking process beforehand so that the assignee remains in control of the assets for as little as possible. Now, again, the license may not transfer for 6 months or longer, but what could happen is there could be a 6-month investment banking process. When the company identifies the party that's likely to purchase, they initiate the ABC. The assignee looks at all of the marketing efforts to establish that that's the highest and best value, sells the assets, and enters into an MSA, whereby the buyer is operating the entity, paying all expenses as it goes forward, and the S&E is really there for the nominal purpose of being technically the owner of the license until until it transfers over. I'll also note one other thing, which is that we alluded to this early in the presentation, but dealing with the regulators is not, it's not super easy. It's not as if they're always super responsive. They don't all understand what ABCs are. They understand receiverships a lot more. But point being, if you're going to initiate an ABC and it involves the license transfer, you know, there's some risk to it, especially outside of California. California is more adept at understanding both means of both insolvency vehicles.
Yeah, I mean, our experience with the regulators is as this a theme of our discussion today, it varies by state, right? And some of them are willing to try to work with you to get things accelerated because you're saying this business is in crisis, right? And some of them, because they may say, look, we don't want to lose a licensee if we can avoid that by accelerating things. And some of them are not sympathetic at all. There's like, yeah, well, you got to jump through all the hoops, and the timeline is a timeline, and I'm not going to try to move you up the schedule to get you approved, you know, in a couple of weeks. You just got to get in line with everybody else. So that's the unfortunate truth of the matter. I think we got about 10 minutes left. So let us hit Canada.
So I'll hit this pretty quickly, and then I'll turn it over to you, Brent. But basically, what I'd say, what was it, 10 years ago now, maybe longer, there was sort of a rush to Canada because cannabis companies are federally illegal in the U.S., but not in Canada. All of these U.S. entities, without any operations in Canada, created a Canadian holdco. And this Canadian holdco was there so that they could be listed on the Canadian Stock Exchange and raise a ton of cash to either, you know, bring some value to the owners, or alternatively to raise capital to actually grow the business, depending on the individual business. And what's happened is that as these businesses in the U.S. have started to suffer, and we alluded to this in the problems early on, you have these costs of remaining public in Canada, and the stock price for a lot of these cannabis industries is just essentially penny stocks at this point. They're not super valuable.
Right.
And so we've worked extensively with Canadian firms who have more experience liquidating these companies than U.S. firms, largely because the Canadians have been dealing with it for longer. There's more and more of these things that are happening, and they all implicate the Canadian holdco, even though, again, there's no there's you know, in many instances, no operations, no enterprise in Canada.
Yeah, except the parent company does incur obligations, right? It's got usually by the time you're hitting this situation, they probably have a bunch of unpaid bills to attorneys and accountants at the parent company because of the ongoing compliance obligations. And our experience, I think, was that trying to go through a Canadian insolvency proceeding didn't solve the problem. It was just another layer of effort, right? You'd still have to do some sort of receivership or ABC process in the U.S. for the local companies. So unfortunately, I think that those companies that went public in Canada and then are now struggling, if and when they do hit the wall, they're just another layer of, you know, it's expensive to be poor in America and in Canada.
Yeah. So in a CCAA is the Companies Creditors Arrangement Act in Canada, and it's akin to a Chapter 11 reorganization. The BIA is a Bankruptcy and Insolvency Act. There's also something called a receivership, which I believe is similar. In all three instances, a third-party neutral is replacing management. They're taking over. They're going to be the person or people who are running the show. And it's, you know, what's often happening is that the holdco in Canada will initiate a CCAA or BIA or something along those lines. And then there needs to be an accompanying process in the United States to deal with the U.S. assets. So it's a way of putting a bullet in the holdco while you deal with the, while you deal with the U.S. entities in their own way.
Yeah, I don't really have anything to add on that. I think that's
Totally fine.
All right, let's do, we got 5 minutes. We can talk about chapter 15, or we can do the Michael Brandis show on chapter 15, and I'll make color commentary.
I'll be quick, and then we'll do the war story. We'll have a little time for war stories or any questions. Chapter 15 is part of the bankruptcy code. And mind you, I spent the entire presentation talking about how it's federally illegal. It still is. But there's been in certain bankruptcy courts, more of an appetite to allow cannabis adjacent businesses or to go through bankruptcy, whereas certain other courts have been much more restrictive. Chapter 15 is the recognition of a foreign proceeding. So let's say that a company in, let me use this, JAL Airlines, a Japanese airline, filed the equivalent of a bankruptcy in Japan when I was starting my practice like 16 years ago. And they had assets in the US, and so they needed the US to recognize the foreign proceeding happening in Japan so that the reorganizational efforts in Japan would also cover the US assets. I know it's complicated. It's complicated to everybody, but it's basically a means of having the arm of other reorganizational or liquidation statutes or country statutes cover U.S. assets, U.S.-based assets. So there's been a lot of talk amongst people in this space, in the very discrete space of cannabis and distress, about, well, what about cannabis? Because while the U.S. bankruptcy law does not allow for a cannabis business to go through bankruptcy, what if it's just a recognition of a proceeding going on in a foreign country like Canada? So there's been talks about, how do you avail yourself of Canadian jurisdiction? Is it enough to open a bank account? How do you do it? What's going to be recognized? Where is it going to happen? It would be super interesting to see whether or not a company could properly reorganize using a foreign country's statutes and then seek U.S. recognition through Chapter 15 of that proceeding, because it'd be a backdoor way into a reorganization. Hasn't happened yet, but the bankruptcy nerds out there are very excited to see what happens when it does. That's
Why hasn't it happened? Why hasn't it happened yet? We don't know. It's just because
cost,
it'd be
risk.
Cost. Yeah. Fair enough.
It's a risky proposition.
Right. Nobody really wants to be the first mover because it's super expensive and you may not get what you wanted.
Ultimately the academic question is really fun for us, but our clients are more interested in money. And so if there's less certainty in this process, then it really has to make sense. And it just seemingly hasn't made sense yet to the right group of constituents of borrower, lenders, so on and so forth.
Fair enough. Fair enough. All right. Well, we have like a minute or two for fun war stories. I'm not sure I have a great one on tap that I can tell.
Yeah. So I can. I'll talk about one generically. One is there's a receivership happening in one state. There's a question as to assets in another state, whether or not the receivership order covers the assets in those states. And in this case, the assets are in Illinois, where there is no current receivership statute. It's just common law. So the question is, well, how do you go about making sure that the receivership in one state covers the assets in the other state? And we're talking about whether or not we get an order in the first state, whether or not we couple it with an ABC. And because this is less of a war story, and I apologize, it's more of an academic issue, but it really, it plays into the need for creativity and the appetite for just perennial risk. That if you're in this industry, there's just risk in everything. Even in insolvency, there is risk. And that risk in an insolvent situation is the loss of license and successor liability, which means that the debts of an old co will follow through to a new co. And so we lawyers like certainty, but in this instance, it's an inherently uncertain industry, and insolvency doesn't necessarily make it more certain.
Yeah, I mean, I guess my parting thoughts would be this is a heavily regulated industry, and the regulator is the state that you're in. You got to make sure that you're on top of the regulations there, and don't wing it, because if you do, you could end up losing one of the primary asset of the business, which is the license. So, all right, I'm going to read us out. Thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the continuing education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of this webcast. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes the webinar. Thank you very much. Have a good day.
Thank you.